So we are discussing the topic, the reference of the President of India to the Supreme Court of India under Article 143 of the Constitution. So this topic deals with the two constitutional authorities, that is the President of India and the Supreme Court of India. And besides, this topic deals with the advisory jurisdiction of the Supreme Court of India. So the thematic representation is, first is legal analysis. What are the constitutional bases of this topic? Article 143 establishes the advisory jurisdiction of the Supreme Court. That means whenever a constitutional matter arises, the President of India can ask uh, advice of the Supreme Court of India. And when this advice is taken, it is taken upon the two facts, that is question of law and question of fact of public importance. Obviously, if the question of highest legal importance in the country arises, it is the Supreme Court, which is the highest court of interpretation, that can answer this question. Second basis is the scope of the advisory jurisdiction. Deference can be made for any matter where legal clarity is the necessity. If a matter has legal ambiguity, a term is carrying more than one meaning, obviously it is the Honorable Supreme Court that provides the maximum interpretation of that answer. And second, it is on significant national interest. That means generally the question of regional interest, or generally the question not involving the question of law, question of fact, are not discussed by the Supreme Court of India. Next is, there are two types of references. First is under Article 143 and second is 143 subclause 2. This is of great importance if we refer to them. Public importance question. Supreme Court may accept or refuse to give the opinion. So under Article 143 subclause 1, Supreme Court has the discretion that even after the presidential references, the Supreme Court may or may not give the opinion. The Article 143 subclause 1 carries the word may. That means that jurisdiction is not mandatory upon the Supreme Court. Supreme Court is not bound to give such opinion. Whereas, if we come to Article 143 subclause 2, disputes from pre-constitutional treaties and agreement, Supreme Court must give its opinion, because if pre-constitution agreement and agreements or treaties are not interpreted by the Supreme Court, then who will do this? So therefore, Article 143 subclause 2 carries the word shall, whereas the Article 143 subclause 1 carries the word may. That means in the same jurisdiction, at one level Supreme Court has the discretion to give the advice, at other level the Supreme Court is bounded or has the mandatory necessity to give the opinion. What is the nature of the Supreme Court's opinion? The opinion of the Supreme Court is advisory. It's not a judicial decision. It's not binding upon the President of India. So if we take it from the perspective of the President of India, whether the opinion has been given under Article 143 subclause 1 or whether under Article 143 subclause 2, none of the opinion given by the Supreme Court is binding upon the President of India, irrespective of the fact it's dealing with the pre-constitutional agreements or not. Next is significance and utility of this provision. It provides the authoritative legal guidance to the government. So whenever there is a legal question arises, be it the fact or be it of the law, the government has some form of aid from the Supreme Court. Second, aids in informed decision making. That means the decisions are based upon the legal rationality. And third is, helps prevent the future legal disputes. Obviously, when the Supreme Court makes a decision, it becomes a precedent. Supreme Court is the court of record, and its authority is accepted throughout the country. Therefore, it provides finality to the fact that over which the Supreme Court has given its opinion. So obviously, Article 143 solves many of the issues when the Supreme Court exercises its jurisdiction. So the core theme of the topic is Article 143 empowers the President to seek the Supreme Court's non-binding advisory jurisdiction. But non-binding is applicable under Article 143 subclause 1 from the perspective of Supreme Court. But when it comes to a word non-binding, here the non-binding is applicability upon the President of India. So none of the opinion, be it of Article 143 subclause 1 or be it the Article 143 subclause 2, are binding upon the President of India. So none of the opinion can be binding. Non-binding advisory opinion on important legal factual matters, aiding informed governance and constitutional clarity. Obviously, this opinion provides the basis for smooth functioning of the Constitution of India. If you have any question over this topic, you can ask me in the comment box. I'll try to answer your question. Thank you.